is Patrick Simasko, an elder law attorney with Simasko Law Offices. And today I'd like to talk about a topic that's very, very important, is how to fund your revocable trust agreement. Funding a trust is the most important part of the process. And I like to equate it to, you go out and buy a brand new car, but you don't put any gas in it, it's not going to go anywhere. Or you buy this brand new car and you don't put any oil in it and the engine's going to blow up and everything is just going to go horribly, horribly bad. So when you get an estate plan that has a revocable trust, that's just the first part of the process. A trust is a big bowl, and when you fund the trust, you're putting the assets into the trust. You're putting the assets into the bowl. Everything that's in the trust will be administered by your trustee and distributed to the beneficiaries. So it's critical to make sure that all of your assets go into the trust either while you're alive or if you should pass away. So the question next is, well, how do I fund my trust? Well, the way that you fund your trust is you have to look at each one of your assets individually. House, cottage, cabin, condo down in Florida, bank accounts, life insurance. You have to look at each one of those assets, and they're all handled a little bit differently. So let's talk real estate. Real estate is, while you're alive, you sign a quit claim deed that changes ownership of the house from yourself to the trust that you created. So it goes from mom and dad to mom and dad as trustee of the trust. You still have authority to sell your house. You can do anything with your house with that revocable trust, but when it's in the trust, it's going to be covered by the trust if you should get sick or pass away. Cottage, real estate, it all handled the same way. The next is your bank accounts. You physically have to take your trust to the bank and tell the banker to change ownership of those accounts or the beneficiary of those accounts to your trust. So if you pass away, it's going to go to the right beneficiaries. Life insurance. Life insurance is covered by beneficiary designations. So you have to contact your life insurance companies and have the beneficiary be your trust. Broker accounts, same way. You go to your stockbroker and you put the titling in the name of the trust. Annuities, the same way. You make the beneficiary either the owner or the beneficiary of your accounts is the name of your revocable trust. This is the only difference. If you have any IRAs, 401k plans, 457 plans, any of those type of retirement accounts, they cannot be owned by your trust. They have to be owned by you individually. You die, your spouse's primary beneficiary. Then if you and your spouse are gone, the trust or your kids are named second beneficiary, and that's sort of complicated. You want to make sure that the trust that you created, in my opinion, you want the trust to be named as second beneficiary, and that the tax benefits flow through the trust down to your children and grandchildren. Very important. You have to make sure whoever's funding the trust and whoever created that trust for you, it's a flow-through trust. It's very, very important, or it could have some huge negative tax consequences. Now, what if I don't fund my trust? That's when the problems arise. Big, big, big problems are potential. And this is what I mean. We all know that we want to avoid probate. So mom has 5 kids. The trust agreement says that mom dies, everything goes to the 5 kids. But she wants to avoid probate, so she puts everything in her oldest daughter's name. Mom dies, who gets the money? The oldest daughter does. Beneficiary designations, joint ownership designations. Whoever's on that account gets the money, not who you want it in the name of the trust. So you have to name the trust as beneficiary of those accounts. So mom dies, it goes to the oldest daughter. It would be up to her to decide if she wanted to split the money up between the other brothers and sisters. She doesn't have to, or that's where the war starts. Next problem is you name all 5 kids as beneficiary of your trust. Very typical. Daughter dies, you want her share to go down to her kids. If you name the kids as beneficiaries on the life insurance or the retirement accounts or the bank account. So mom dies, it goes to the 5 kids. Very typically, those accounts say if little Mary dies before mom, her share goes to the other brothers and sisters. It doesn't go down to the grandkids or the deceased child's children. Trust says Mary dies, her share goes to her kids. The beneficiaries, if you set them up with the account, Mary dies, it goes to the other brothers and sisters. There's the war. There's no reason, or the children are not obligated to pay the grandchildren their deceased parent's share. Again, that's where the war, families get split up, everybody hates each other, and the biggest problem is because the creator of the trust didn't fund it properly, or she thought that the beneficiaries would follow the trust. They never do. So, the key for any good estate plan, just like any brand new car, is have it full of gas, full of oil. Trust, same way. You want to create the trust, and you want to have all the accounts in the trust while you're alive, or if you should pass away, so it flows to those people that you want it to go to under the terms that you laid out. So if you have any problems, please give me a call. Again, my name is Patrick Simasko of Simasko Law. I'm an elder law attorney. We do estate planning, Medicaid planning, VA planning. We have offices up in Port Huron, in Mount Clemens, and also in Southfield. So hope to hear from you. Until again, thanks a lot. My name is Patrick Simasko.